All right, everybody, we will go ahead and get started with today's event. This is our Law Day celebration. For those that don't know, Law Day 2022, the theme is toward a more perfect union, the constitutions in times of change. Even though Law Day is usually celebrated on May the 1st, that was on a Sunday, so we decided to push ours back and hold that celebration today. It's an opportunity to participate in discussions about law and its role in the society. And I'm excited today to have Professor and recently confirmed Judge Jeffrey Usman be our speaker. So you can go ahead and get started with your presentation.
Thank you very much. Thank you to Mr. Cole and Director Clayton and the entire team with West Tennessee Legal Services. I appreciate the opportunity to have a chance to talk with you all today about this topic here, the Law Day theme from the ABA this year, toward a more perfect union, the Constitution in times of change. And we're certainly living through a time period that's extremely divisive. It feels at times as if the sort of social fabric is being pulled apart in this country. So you'll even hear it stated that this is the most divisive time. That's wrong. It's inaccurate at the very least. This country has experienced a civil war, and the country's been torn apart through violence, firing upon Fort Sumter that launched a massive and bloody war that cost hundreds of thousands of lives and which completely changed the country. I think that a sense of history here can be helpful for us in thinking about constitutions in times of change and some of the dangers, some of the possibilities, how we should think through some of these issues of constitutional change. And because the time period, sort of greatest constitutional change, other than the founding itself, is the Civil War Amendment time period, that time period from 1865 to 1870 that sees the 13th Amendment, the 14th Amendment, and the 15th Amendment to the United States Constitution dramatically transform the original Constitution that was. And so I want to walk through that a little bit and then think about some of the complications and challenges of interpretation and some of the damage that may have been done along the way by the court in terms of its understanding of some of these measures. Our starting point here, I think, with the 13th Amendment to the United States Constitution, which of course prohibits slavery and involuntary servitude. When the war begins, I think it's important for us to reflect upon and consider that the war aims are not originally, Lincoln's aim at least, is not originally to end slavery. Instead, it's preservation of the Union. It's during the course of the war that there is a movement nationally. There's a movement in the northern states in the direction of slavery has to come to an end. And the slavery had been a price of peace, of holding the Union together. And here, through the bloodshed of the Civil War, that price has been paid in terms of bringing to an end this horrible institution. The commitment ends up being there, and you have the termination, the ending of the institution of slavery with the 13th Amendment to the United States Constitution, something that really could not have been envisioned 5 years earlier with any level of political reality to that aspiration. It becomes a reality of constitutional transformation with everything that's going to flow from that, including a complete transformation of the Southern economy and the economy of the border states also as a result of the 13th Amendment. The 14th Amendment arrives in part because of the response to the 13th, as a response to the end of slavery. It's the response of Southern states essentially, and this proves to be shocking and alarming to citizens in the North, in part because what Southern states start to do in the immediate wake of the end of slavery is to reinstitute slavery in everything but name. And there's prohibitions upon the movement of former slaves. You can't travel, you can't move at night, you can't move unless you have a pass. You have to sign extended contracts of several years with ridiculous conditions. You can't negotiate or bargain with regard to your labor. The restrictions that are imposed, essentially, even measures with regard to punishment and sanction and the use of physical violence being authorized against former slaves. It's essentially a reinstituting of slavery in all but name. And this is going to end up shocking, really, the public in northern states. And so there's, before the Civil War, a lot of the ideology, a lot of the political rhetoric of the sort of nascent Republican Party is tied to free soil, free labor, and free men. And so the idea of constraining slavery, of limiting slavery, but another important piece of that is free labor. The idea that labor shouldn't be enslaved. Instead, there should be freedom of labor, this opportunity to work, that's more, there's greater opportunities for economic development, for personal liberty, all tied to that idea of free labor. And the response is just so contrary to that ideology. It makes a mockery, essentially, in many respects, of the 13th Amendment. And so you end up with, in response, the 14th Amendment. There's still limitations, huge limitations, built into the 14th Amendment in terms of where they didn't go. What's missing here is voting rights, sort of full participation as a citizen in the form of voting and being able to cast a ballot, being able to participate in the democratic process. And it's that further sort of that recalcitrance, that limitation, that pushback from in southern states that helps to inspire the 15th Amendment. And so you get the right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of race, color, or previous condition of servitude. Those 5 years between 1865 and 1870, these 3 constitutional amendments completely transform or dramatically transform the nature of constitutional safeguards, constitutional protections in the United States. You have the end of slavery. You have the enshrinement, the overruling of Dred Scott, one of only 4 U.S. Supreme Court cases to be overruled through constitutional amendment, with birthright citizenship, the Privileges and Immunities Clause of the 14th Amendment, the Due Process Clause, the Equal Protection Clause of the 14th Amendment, all of which are moving towards greater rights of citizenship and protection against violations of civil rights by the states. And in the 15th Amendment, that right to vote, that full participation as a right of citizenship in voting, putting a sort of encapsulation on what had happened. Senator Carl Schurz probably did about as good a job as anybody has in terms of thinking through what did all of this mean? How does all of this work? What's been created here as a result of this dramatic constitutional transformation? What does the result of the great constitutional revolution signify? The war grew out of a systemic violation of individual rights by state authority. The war ended with the vindication of individual rights by the national power. The revolution found the rights of the individual at the mercy of the states. It rescued them from their arbitrary discretion and placed them under the shield of national protection. It made the liberty and rights of every citizen in every state a matter of national concern. Out of a republic of arbitrary organizations, it made a republic of equal citizens. Citizens exercising the right of self-government under and through the states, but as to their rights as citizens not subject to the arbitrary will of the states. It grafted upon the Constitution of the United States the guarantee of national citizenship. This enormous constitutional transformation that's earned the Civil War amendments, this time period, a designation as the Second American Founding, this time period of a second founding of the nation. What happens to all of that? And I think what we see in terms of judicial response to that constitutional transformation can really help us in terms of understanding some dangers with regard to constitutional interpretation, some dangers with regard to the preservation of civil rights, There's a lot to learn there in the experience of what unfolds next, what happens next in the wake of these constitutional amendments once they reach the courts, once there's further resistance to these measures in the states, and as Reconstruction government starts to disappear, military government starts to disappear from the southern states. And what happens, what was wrought here, what was created, what was generated through this constitutional transformation. There are moments where the court seems to be giving effect to the constitutional transformation that has occurred through the Civil War amendments. I think two cases that really jump, I think, that warrant attention in terms of the court reflecting upon, giving effect to that constitutional transformation are Strauder, and the second case is Yick Wo. Let's start here with Strauder. In terms of Strauder, the state of West Virginia provides that African Americans cannot serve on a jury. On the face of the statutory provision, West Virginia provides African Americans simply are ineligible for jury service in the state. Constitutional challenge is brought in Strauder, the argument being made that there wasn't a fair jury trial here, that this is discrimination on the basis of race with regard to how juries are impaneled, selected, determined in the state of West Virginia. And the United States Supreme Court is going to agree. The United States Supreme Court is going to invalidate the West Virginia law. West Virginia, you cannot impose a limitation that precludes African Americans from being able to serve on a jury. You can't put in a statute as a matter of state law that prohibition. It's a violation of the United States Constitution. That's the effect of the Civil War amendments at play. That's that constitutional safeguard being applied to the states. And don't forget, Barron v. City of Baltimore, prior to the Civil War amendments, Bill of Rights don't apply to the states. The 14th Amendment, created after the Civil War, is going to be a vehicle, a conduit for application for constitutional rights being read in, but that those constitutional safeguards, those constitutional limitations being imposed upon the states, we see that transformation starting to find its way. And this is very early in terms of what we're looking at, but it's starting to find its way in cases like Strauder. Then we have Yick Wo. So Yick Wo, case that's sort of immersed deeply in concepts of equal protection. You have a prohibition by the city of San Francisco on operating laundry facilities in wooden structures. No laundry facilities can operate in wooden structures. There's special permitting exception. And you have here a measure that at its core looks like something that could be public health, welfare, safety related. Wooden structures, laundries at the time, danger catching fire. And so city of San Francisco is going to protect the public from the danger of fires being caused in laundries operating in wooden structure buildings. The problem in Yick Wo is one of application. Who's actually having their laundry business shut down and who's not? Well, the only persons that are being targeted here are racial minorities, persons of Asian descent, who are being targeted in terms of the actual application of the law. If somebody's of European descent, then they get to keep operating their facility, even though it's in a wooden structure, even though it poses the same risk. They get to do so. Persons of Asian descent do not get to do so. And the United States Supreme Court in Yick Wo is going to conclude that's unconstitutional, violates the United States Constitution, can't do that, impermissible. Strauder and Yick Wo both reflect the constitutional transformation, that constitutional change that we see with the Civil War amendments, the changing nature of the relationship between the federal government and the states. But we're also going to see fissures. We're going to see places where the Supreme Court is not embracing the full constitutional change that's occurred. And I think there are interesting questions to think about in terms of why that is. Why didn't the US Supreme Court fully embrace that transformation? What's leading to that? And I think part of what's driving that, it has to be said, are sort of built-in racist tendencies among many of the justices of the era who had a hard time seeing any sort of sense of equality. and embracing any sort of sense of equality in terms of interaction, in terms of ability. There's some real limitations that I think we see in the justices. And one of the places we see those limitations really start to break the effectiveness of the Civil War amendments is here in the Virginia Commonwealth of Virginia case involving jury selection issues. So this is essentially argued same year as Strauder comes up before the U.S. Supreme Court. It's part of two different cases that made their way to the U.S. Supreme Court involving the same underlying question, which was connected with a prosecution, a murder prosecution in the state of Virginia, in which no African Americans had served on a jury. And you have a federal judge essentially decide that the state of Virginia is in violation of federal civil rights laws with regard to its actions, institute essentially action against the state judges in Virginia who are operating their courtrooms in a manner where jurors are being excluded on the basis of race. Now, a critical distinction between the Virginia case and the West Virginia case is Virginia did not have a statute that precluded somebody from serving on a jury on the basis of race. Instead, this was being done on a much more informal level. It was not necessarily always spoken or uttered, but it was very much the effect. In the particular county at issue here in this case, where the underlying murder prosecution had occurred, there had never been, not once, a juror who was African American in a county that had a substantial African American population. No juror had ever served in this county who was African American. The case works its way up to the U.S. Supreme Court, and the United States Supreme Court is going to draw a distinction between cases like Strauder, where West Virginia puts on the face of the statute a prohibition, can't serve on a jury if you're African American. That's violative of the Constitution. That's unconstitutional action, violates Civil War amendments. And the Commonwealth of Virginia case, where you have instead a more informal process, no less effective in terms of the racial discrimination that's playing out, but a process that's not written into the face of the statute itself, where essentially the U.S. Supreme Court is going to take the view, well, there are all kinds of reasons, and there's not a systemic violation. Thinking about that sort of determination case, never has there been an African American juror that served in the entire history of this county, and yet the U.S. Supreme Court doesn't see any basis for finding a systemic violation with regard to racial discrimination. That determination itself has a deep-rooted sort of underpinning of the racial white supremacy that I think you see among a number of the judges of the era, that there's sort of all these other justifications, exceptions, reasons. This split is going to become a conduit essentially for a structure of racial discrimination and jury selection that's going to play out over the course of the next 80, 90 years in the United States, where states don't pass laws that create formal racial discrimination and jury selection. Instead, you use processes like jury commissioners who are supposed to go and identify good, respectable citizens who should serve on juries, and then you impanel juries from those jury commissioner selected persons who end up being all white. And so there's a sort of not that on the surface discrimination, but very much discrimination that's occurring, and discrimination which is clearly violative, and which the court would later say, nearly a century later, the court would say in the 1960s and then the 1980s, the court would impose restrictions, limitations with regard to racial discrimination in jury selection. But here, this backstep by the United States Supreme Court, or failure to sort of fully embrace the impact of the Civil War amendments, becomes conduit for an incredible amount of racial discrimination in this country. We also see, I think, the failure of the United States Supreme Court to fully embrace the transformation, that sort of second founding that occurred in the slaughterhouse cases. And so if we think about Justice Miller's majority, in this case, these cases come out of litigation tied really to economic liberty issues with regard to butchers operating in Louisiana and limitations that are imposed with regard to the trade of being a butcher in the city of New Orleans. And so you have in this case, at the core of it, in terms of what's going to become a sort of constitutional strangulation by the court, where the court's going to very much limit the impact of the Civil War amendments in some pretty unnatural ways. The Privileges and Immunities Clause. So let's go back to the language of the 14th Amendment itself, Section 1 of the 14th Amendment. So first provision, right? All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That's the reversal of Dred Scott, right? Dred Scott reaches the conclusion that African Americans cannot be essentially citizens of the United States. Birthright citizenship protection, first part of the measure, 14th Amendment is going to overturn that decision. Second piece of Section 1, no state shall make or enforce any laws which shall abridge the privileges or immunities of citizens of the United States. Nor shall any person in the Due Process Clause, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protections of the law. So we've got the Privileges and Immunities Clause, the Due Process Clause, and the Equal Protection Clause. If we look back at the ratification process, the framing process of the 14th Amendment, it's very clear that the Privileges and Immunities Clause was supposed to play an enormous role, a significant role. It is the center of considerable attention in terms of thinking through the 14th Amendment, arguing over the 14th Amendment, its framing, its ratification. What does the US Supreme Court do with it in the slaughterhouse cases? It essentially strangles it. It's sort of a boa constrictor problem here. And the court takes away the vitality of the Privileges and Immunities Clause and essentially reduces it to who knows what. And it's rights that you don't have in connection with being a citizen of the state that are unique to national citizenship. It's not intended to apply to places where we conventionally think of civil rights. It's more limited in terms of its scope. And it's going to take, by the way, it's going to take almost or more than a century really for the court to find anything that it really finds a meaningful home in for the Privileges and Immunities Clause of the 14th Amendment. And that's going to end up being one aspect of the right to travel. Is going to be grounded in the Privileges and Immunities Clause. Justice Bradley, doing a fair amount of mocking of his colleague, especially for a collegial court of the era, essentially looks at it and says, well, what was all the big fuss about then with the Privileges and Immunities Clause? And surely it was meant to do something more than this, this being undefined and unknown in terms of how Miller's thinking through what's at play in the slaughterhouse cases. And so you see this court that in many respects is driven by a sense that, well, the Constitution as they knew, as they studied, as they understood prior to the Civil War amendments, had didn't have this role for the federal government in policing rights, civil rights measures. That wasn't part of what the federal government did. That was the province of the states. The federal Constitution only protected against the federal government violating your constitutional rights. And that's Barron v. City of Baltimore again. The justices here in 1873 are having a hard time getting their minds through the constitutional transformation that occurred between 1865 and 1870. They're struggling with that dynamic, and we see them here as part of that, really strangling the life out of the Privileges and Immunities Clause of the 14th Amendment, making it almost a nullity. And so I think one of the dangers that we see in terms of constitutional amendment, in terms of constitutional transformation, is that strangulation, that limitation, that not giving effect to the right that was enshrined, the change that was enshrined. It's inconsistent with what was before. And you see the court reading in limitations based upon what was before, rather than the constitutional amendment, that constitutional transformation that's occurred. We then, once the life has been drained significantly out in cases like the Commonwealth Virginia jury case, in cases like the slaughterhouse cases, then we see the court really reaching, I think, the height of violation, running afoul of the second founding itself in Plessy v. Ferguson. And so if we're thinking about Plessy v. Ferguson, of course, we're talking about separate but equal concepts and the vision essentially of a society that was going to be dramatically and almost fully segregated. You have here a circumstance where a state imposing a limitation with regard to a railway company operating cars, requiring them to operate segregated cars. Railway company doesn't want to. Number of passengers don't want to be restricted in terms of being moved into a racially segregated vehicle or racially segregated train car. And here you have in Plessy, the US Supreme Court signing off on it, ratifying it, essentially saying, no, that's fine. That's consistent with equal protection, and taking a very, very narrow understanding of exactly what the 14th Amendment had done. And here we have this vision of the 14th Amendment as not applying essentially to what the court envisions as a sort of social right. And reading Justice Henry Brown's opinion, you very much have a sense that he's reflecting upon the idea, well, that it doesn't violate the Constitution for somebody to choose to not have dinner with somebody on the basis of their race. Well, it doesn't violate the Constitution for somebody to choose to not have dinner with somebody on the basis of race. The Constitution doesn't protect against that. But Brown takes that concept and reads that into, well, Louisiana can impose a limitation in terms of the operation of train cars that exclude or separate people by the force of state law in terms of how railways are going to operate in this state. And so that's a step dramatically beyond the sort of underlying social concern that Justice Brown has, that's essentially reading itself into law in a way that's completely violent of the rights that are being enshrined and protected as part of that constitutional transformation of the second founding, of those Civil War amendments. And the only one, this is an 8-1 decision. It's the lone dissent, right, is Justice John Marshall Harlan I, with Justice Harlan essentially looking at this as a complete violation of the rights that were enshrined in this sort of defining constitutional moment of change and possibility and reaching to sort of provide for that greater protection of citizenship and civil rights that we saw with the Civil War amendments. Harlan's the only voice that's essentially seeing the constitutional strangulation that's occurred of the Civil War amendments by the United States Supreme Court. With that, it's going to take decades for the US Supreme Court to work its way out of the missteps of the United States Supreme Court. And part of that sort of stepping out, moving beyond part of those mistakes is only going to be arrived at through a remarkably brilliant litigation strategy that is put in place with the combined work of Charles Hamilton Houston and Thurgood Marshall, who are going to push upon Plessy in a variety of ways. Some of them pushing on, well, equal is equal. So if it's separate but equal, showing disparities in terms of funding level between schools that, for example, white schools that have new textbooks, materials, better classroom space, more teachers, and schools for African American children that have dirt floors, no books, and huge limitations in terms of their operations. So part of the litigation strategy is to push on equalizing equal, which imposed significant financial costs on states that were engaging in segregation because of the cost of operating a dual system of education, a dual system of essentially local governmental services and state services. So that was one part of the strategy. The other was to go to the court essentially with plaintiffs that were selected in part because the way the court would understand or identify with that person. And so one of the targets there is graduate students, and taking on graduate students, medical school, law school in particular. A number of law school student cases are brought, in part because the judges get it. They understood it. It's something that was part of their experience, their worldview. So when you say, for example, that you have, for example, the state of Oklahoma will allow an African-American student to attend their state law school, but the student has to sit in a special segregated area that's to the side where they can't see what's going on in the classroom as well, and they can't interact with any of their peers at all, any of the other students who are white at the law school at all. The justices understand that part of the law school experience is not just what's heard or spoken, but the interactions that occur between students after. It's the questions, it's the discussion, it's the conversation that help facilitate understanding. And that's something that Charles Hamilton Houston and Thurgood Marshall were very much tapping into, and which bore fruit and sort of more fully with the sort of biggest issue that was driving much of the litigation or underlying a lot of the litigation with the integration of K through 12 education through Brown v. Board of Education, and which would sort of inspire its own resistance to the constitutional decision of the United States Supreme Court and require essentially decades of continuing litigation with regard to desegregation issues. So we end up, though, that initial strangulation still hasn't been fully remedied. If we think about slaughterhouse cases, for example, Privileges and Immunities Clause, the 14th Amendment, still remains almost lifeless in terms of its approach. And so that initial resistance to constitutional change, that initial strangulation, well, there has been a sort of significant movement in terms of some of the more subtle, not really subtle, but non-facial racial discrimination actions, or sort of the business-connected Yick Wo style violations. We still haven't sort of seen that complete restoration. There's a harm caused by that initial strangulation that still hasn't fully been sort of enlivened to this day by the courts. I want to talk, so if one potential problem with regard to constitutional transformation, times of change, how we think about constitutions and sort of how interpretation is going to fit on top of this, is that strangulation, that overly limiting, that taking the air out of constitutional provisions. The other danger, I think, is sort of on the other extreme. I like to think of it as sort of the Icarus problem, the constitutional measure that flies too close to the sun in terms of interpretation by the United States Supreme Court. Now, we talked about with the 14th Amendment, that part of what the 14th Amendment, or big part of what's inspiring the 14th Amendment, is the incredible level of attempting to reinstitute slavery in all but name that's occurring in southern states in the wake of the Civil War, where you have these codes that are instituted that essentially impose incredibly draconian limitations on freed persons. Congress, and there's enormous tension in this time period between Andrew Johnson, who's essentially looking to bring southern states back in as quickly as possible, and the Republican Congress, which is looking to give a larger effect to Reconstruction in terms of how this process is going to play out. We do know that one thing that the 14th Amendment was trying to give effect to, an important one, is Section 1 of the 1866 Civil Rights Act. So the 14th Amendment is supposed to give life to this earlier statutory provision. So the Civil Rights Act being enacted by the Senate, House of Representatives, United States of America, and Congress assembled, that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. We see the birthright provision right there. And such citizens of every race and color, without regard to any previous condition of slavery or involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall have the same right in every state and territory of the United States to make and enforce contracts, to sue, be parties, give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property, as is enjoyed by white citizens, and shall be subject to like punishment, pains, and penalties, and to none other, any law, statute, ordinance, regulation, or custom to the contrary, notwithstanding. And so we have here essentially a measure that I think it's fair to say has certain economic rights-based ideas behind it. And part of that is going back to that free labor versus slavery fight that's playing out in the 1850s in the United States. And so that ideology connected up with this pushing back against Southern states that are trying to reinstitute slavery in all but name. We can certainly see this understanding of economic rights, economic liberties, that's part of what Congress is aiming at, part of what the 14th Amendment is aiming at in terms of the safeguard. Now, the Icarus problem becomes this. The court took the sort of underlying economic rights, economic liberties that we see in the 14th Amendment, or that are sort of the cornerstone of the 14th Amendment, and they take them in this direction of becoming very aggressive with regard to economic policy. And so the court, instead of keeping things sort of between the lines, imposing certain limitations where states have gone too far, you have a court that gets pretty aggressive in terms of how it's looking at economic liberty. And so from the late 1890s until really 1936, 1937, you see the United States Supreme Court policing the economic ordering of society by states, local government, and by Congress in significant ways. And so the policing going a bit too far. So if we see with regard to the slaughterhouse cases, this strangulation not giving effect, I think we see with the Lochner era, the consequences of going too far the other way in terms of the court becoming an economic policymaker rather than keeping things within bounds of what was provided with regard to certain constitutional limitations on this front. So much more aggressive application, flying too close to the sun, so to speak, in terms of how this plays out. And the consequence of that ends up being the United States Supreme Court deciding to completely abandon the field. So we have, I think Carolene products certainly a critical case in doing this. You have Congress imposing a restriction with regard to filled milk, with regard to mill nut, with regard to products, non-dairy milk products here, where it's clear the legislation is driven by economic protectionist ideas with regard to a very influential dairy industry that's impacting federal legislation. And the United States Supreme Court in Carolene products is going to launch in a direction of what's going to become sort of our modern rational basis analysis. I think one of the critical provisions in the case is language in the case is this here. The existence of facts supporting legislative judgment is to be presumed. For regulatory legislation affecting ordinary commercial transactions is not to be pronounced unconstitutional unless, in the light of the facts made known or generally assumed, it is of such a character as to preclude the assumption that it rests upon some rational basis within the knowledge and experience of the legislature. What is it that Stone's saying, and what is that all about? Well, and I think what we see here from Justice Stone is essentially the precursor of the idea that whether it's true or not, and is spilled milk actually more dangerous? Is it actually going to cause any harm to anyone? Is mill nut something we should all avoid? Is Congress right about this? And essentially Stone's saying, I don't care. It doesn't matter whether it's true or not. It doesn't matter whether the product is actually dangerous or not. What matters here is that it's rationally conceivable that the product is dangerous, that it's better to drink dairy milk than it is, whether it's true. And I think that's an important thing for us to recognize here. we're reaching this conclusion, whether it's true or not. Whether it's true or not, it could be untrue and yet still rational. And that is an important transformation in terms of how the court is thinking about economic liberty issues here in Carolene Products. They're essentially taking that step of reaching a determination that this can be constitutionally permitted in terms of this restriction, this approach. That's something that's fair game in terms of something that's within the scope of congressional power. Now, it's completely inconsistent with what we saw in the Lochner era, but the Lochner era had also been very aggressive in terms of its approach. Here, I think we see that the complete opposite in terms of the court is stepping away. And the court, of course, in famous footnote 4 in Carolene Products, announces it's stepping away. And it's the court's telling us in footnote 4 that it's not going to police these economic liberty issues. So from 1890s to 1936, 1937, 1938 here, the court did police economic liberty in a very aggressive way. Here, instead of stepping back, instead of, for example, returning to maybe a position similar to Harlan's in the Lochner case itself, where Harlan finds himself somewhere between Holmes and Peckham, where Peckham has a more aggressive approach, Holmes essentially no role whatsoever with regard to economic liberty, and Harlan envisions some role for the court with regard to policing economic liberty issues, but thinks the court's taking this a step too far, maybe 2 steps too far, in terms of its approach that's utilizing here, utilizing the Lochner case. Stone's going to go in the more Holmesian direction. It's a complete abandonment. We don't police economic liberty, just rational basis, and rational basis is not going to look like a standard that's got really any heat to it, even as announced in Carolene Products, and it's only going to become less so in terms of some of the subsequent cases. And so in stepping away, the court's going to tell us, well, we're not going to police this anymore, but that doesn't mean that the US Supreme Court's not going to police anything any further. Where are there still going to be heightened protections, heightened safeguards? And it's really those 3 categories, right? There's Bill of Rights provisions, there's political process protections, that who gets into office, how do they get into office, what's the process that's utilized, and that's designed fundamentally to protect against those who are in power from being able to insulate themselves against challenge, so that those who are out of power can, through the political process, obtain representation. There's also discriminatory measures directed at discrete and insular minorities. And these are fundamentally circumstances where there is an irrational animus that's driving legislation, driving governmental action, that's targeting a group that's a discrete and insular minority that doesn't have access to political power, and acting out of that animus rather than some sort of rational, reasoned approach to governance. And so those are places where the court is saying we're still going to exercise that heightened protection, that heightened safeguard. And in that footnote, and there's 80 years of US constitutional jurisprudence that's laid out for us. The piece that's missing, and the piece that's sort of probably the most subject to dispute in terms of constitutional dynamics today, is going to be the 1960s sort of era rebirth of substantive due process, not going to be economic, but instead social rights, privacy rights, in terms of those safeguards. That's the one piece that's not encapsulated in Carolene Products that certainly plays a major role in terms of constitutional issues, constitutional interpretation. So post Carolene Products, there are opportunities for the court to have rationality essentially have some limitation in terms of preserving economic liberties, economic rights that seem to have been part of what was at play in terms of the 14th Amendment itself. And the court instead gets increasingly aggressive in terms of reading rational, US Supreme Court gets increasingly aggressive with regard to reading rational basis in a manner that really doesn't allow a lot of room for a challenger to have an opportunity to prevail under the substantive due process economic rights theory. We see it in REA, for example, a case in which where the court essentially accepts the idea that an advertisement on the side of a truck is more distracting if the person who has the advertisement on the side of their truck doesn't own the vehicle. It's not that company's vehicle. Then the same advertisement would be on the side of a vehicle that is owned by the company that owns and operates that truck. That's a hard one to square with regard to a rationality, but the court says, no, that's fine. We're good with that. That's rational basis. We can accept that as being permissible. Williamson v. Lee Optical, in terms of a very protectionist measure that's put in place with regard to ophthalmologists, optometry in the state of Oklahoma, with regard to needing to go get a new prescription. So you walk out of the building, you drop your glasses, and the prescription takes off flying in the air that you had from your ophthalmologist. You can't walk back in and get them recut by the optician. You have to go get a new prescription from the ophthalmologist because you can't cut the lenses without prescription from the ophthalmologist, even if you just cut them a day before, even if you just cut them an hour before. You can't cut them. And so that's something where the courts look at and signs off on, sure, rational basis, that's fine. This is a clearly protectionist measure, and the court's looking at it essentially from a dynamic of, we're going to engage in rational basis analysis. We're not going to use any form of really searching inquiry at all in terms of how that plays out. And then Ferguson v. Skrupa, a protectionist measure with regard to lawyers, with regard to debt counseling, debt information, and the state, essentially, again, the court signing off on this idea. And one of the things I think we see by the time we get to Ferguson is the court is essentially publicly stating, U.S. Supreme Court publicly stating that rational basis is something the government's going to win that challenge with regard to economic liberty. That economic liberty is not going to be have any meaningful sort of life under the 14th Amendment, based upon the approach that the court's using to in terms of its rational basis analysis here. And that's a significant departure, perhaps, from some of where we started in terms of the concern about economic rights and liberties of freed persons, in terms of navigating the economic ordering and relationships in post-slavery society. There's some economic roots there that essentially are largely disregarded in terms of approach. And I think, so we see in terms of this incredible constitutional transformation that occurred, I think two different dangers that are posed with regard to giving that effect in the courts. One, strangulation, and the court didn't give life to the Privileges and Immunities Clause, the 14th Amendment, in terms of there was life there, and it squeezed it out of it, boa constrictor style maneuver on the Privileges and Immunities Clause. And on the other hand, giving too much, essentially too aggressively reading the measure beyond what the Constitution itself would support, with the court becoming an economic policymaker to a significant degree. And that leading to a crash where instead of finding balance, the court largely abandoned in terms of its approach. And so those two dangers, the boa constrictor problem and the Icarus problem, in terms of how does the judiciary respond to constitutional transformation, I think we see two missteps and significant missteps from the judiciary in terms of how they were thinking through constitutional interpretation of the Civil War amendments of this dramatic transformation that's unfolding. What lessons can we take from this that are applicable, perhaps, I think, on a state level or state level of state constitutions? I think there's an opportunity with regard to state constitutions to think through in this dynamic these two errors that were made by the United States Supreme Court and the problems that have been caused by it. State constitutionalism largely became dormant during the Warren Court era. And during the Warren Court era, you essentially have all of the vitality and life of constitutionalism all of the energy, all the air, all the oxygen, it all flows into federal constitutional argumentation. And so that's where the movement was. That's where the dynamic was. That's where new rights were being recognized. That's where the court was taking significant steps with regard to, for example, rights of offenders in criminal cases, equal protection developments, due process developments that continued even after the Warren Court through the Berger Court, I think in some significant ways. State constitutionalism remained largely dormant, though, even after sort of the constitutional approach of the court started to shift in the Rehnquist years and the Roberts years. You haven't seen much of a return to state constitutionalism. I think that in terms of tackling state constitutionalism, there's an opportunity here for litigation. There's an opportunity for courts thinking through these issues in a way that hopefully learns from the lessons of the U.S. Supreme Court with regard to how it approached the constitutional transformation of the Civil War amendments of the Second Founding. There's danger in strangulation, and there's also danger in the Icarus problem, the flying too high and reading some provision beyond what it actually supports or provides for. And so I think one thing that can be helpful for us in terms of thinking through constitutional arguments, constitutional analysis on the state level, as parties, I think, have an opportunity to move forward and make arguments under state constitutions, which, though not new provisions, some of them new, there's still certainly more amendment on the state constitutional level than the federal level. But sometimes it's dusting off old provisions or provisions that haven't really been the focus of argumentation. And for example, there are a number of state constitutions in the country that include healthcare related rights. Well, and healthcare has certainly been a major public policy in this issue in this country for decades. And yet a number of these state constitutional provisions have no reported case litigating them up to the appellate level. And that's extraordinary, considering the amount of public policy attention that's been focused on the national level with regard to healthcare issues. The state constitutional provisions have been left behind. If they're not going to be left behind, if they're not going to be sort of left dormant, if they're going to become a focus of argumentation, I think there's a few things, additional lessons that we can think through in terms of understanding state constitutional interpretation. One, when we're talking about state constitutional interpretation, you're starting from a very different first step, from a very different cornerstone. You have as that first cornerstone, when you're talking about the federal constitution, right? The federal government's a government of limited enumerated powers. It only has the powers that are conferred upon it by the Constitution. Not so with regard to states. States have broad residual authority. They have any authority that's not taken away from them. They can act unless prohibited from acting. That's a very different starting point in terms of thinking about issues of authority and power. Originalism. So originalism on the state level looks different than originalism on the federal level. Well, why? It looks different because the ratifiers are different, and law takes its effect from ratification. The ratifiers, and primarily state legislatures, are engaged in ratification with regard to the U.S. Constitution, and of course, originally conventions, constitutional conventions of the states, specially called. But on the state level, the ratifiers are the people, and state constitutional amendments are ratified by the voters. When you're thinking about ratification by the voters, that suggests an understanding of originalism. We're talking about original intent, whose original intent, original meaning to whom, that it's really the general public's understanding of originalism that drives the analysis, that it's going, the ratifier is the common citizen, is the average citizen. That becomes an important question in terms of thinking through originalism on a state constitutional level. You also have, with regard to function and form, we have extensive policy enshrining instruments with multiple amendment epochs. So we have here, we've been talking today, or sort of this discussion or this talk has been centered on the constitutional transformation of the Civil War amendments. And we can put together a pretty coherent story of what happened with regard to the constitutional transformation, a civil war that begins without a prohibition upon slavery being necessarily a war aim, that becomes an aim after the Emancipation Proclamation, as the war starting to draw to a close. The 14th Amendment, responsive in many respects to the incompleteness of just ending, not just, but of ending slavery, with freed persons being horribly mistreated and degraded. The 14th Amendment providing protection, and then the 15th Amendment coming in and providing that critical citizenship protection, one which was largely, I think it's safe to say, ignored and underplayed in terms of how the court approached voting rights issues, with allowing states that didn't make the Strauder mistake, in the same way that we saw states embrace with regard to jury selection issues. The same consequence flowed with regard to voting rights protections under the 15th Amendment, with regard to strangling the right that was created under the 15th Amendment. We don't see that with state constitutions, in terms of we can't put together that full story, that narrative, that understanding of the dynamic that played out, in part because state constitutions are so frequently amended, in part because they have Tennessee's on its third constitution, the Constitution of 1870, piecing together provisions, bits and parts from different times. It becomes a bit harder, and there also tend to be much more detail, which creates some advantages in terms of interpretation. But it creates a difference in terms of how you approach it. It tends to be more clause-dependent interpretation. It's harder to see the full sort of sweep of what's been occurring with regard to a state constitutional amendment. And that flows into the next point, which is lack of development. And there are roughly 8 trillion books on equal protection, the due process clause, Bill of Rights, not as many on state constitutions. State constitutions tend to have fewer resources, historical, legal analysis. There's less to work from. It makes it harder for, I think, practicing attorneys. It makes it harder for courts to try to understand state constitutional issues, because they just don't have the same materials to work with that you have when you're looking at the federal constitution. And then finally, federalism from a state vantage point. It's sometimes said of state constitutionalism that federalism doesn't come into play at all with regard to state constitutionalism. That I think is a mistake in understanding. Federalism very much does play into state constitutional analysis. It's just from a different angle or perspective. It plays in part because of the influencing on state constitutions of the federal constitution. How is the federal constitution shaping? How is understanding the federal constitution shaping the understanding of the state constitution? Also, just the dynamic of governmental actors having to operate in a universe where they're limited by the federal constitution and the state constitution, and sometimes working collaboratively. For example, joint police task force operations involving state police officers working with federal agents. Well, how does that play out if you're conducting a joint operation where the state constitution wouldn't allow you to do something, but the federal constitution would, as a law enforcement officer? How should we understand that? That creates some complexities in terms of federalism from a state vantage point that shouldn't be disregarded. In terms of thinking about state constitutions and the rights that are protected, I do think it's also worth considering some of the variances termed with some positive constitutional rights provisions. And the federal constitution is not a constitution of positive rights as it's been interpreted by the court. Instead, it's a protection in terms of negative liberty. It's the idea that government can't do something to you, rather than government must do something for you. And that, on the state constitutional level, is different, right? Every single state constitution includes at least one affirmative rights provision that requires the government to act, to bestir itself to act on behalf of affording a right. And so if we're thinking about that sort of positive rights protection, that creates another dynamic of state constitutional interpretation where you have to figure out how to understand positive rights measures under state constitutions. In terms of thinking this through, see we're getting close to the hour mark here, and so I do think there are important lessons with regard to constitutional change and transformation that can be derived from the actions of the United States Supreme Court with regard to how they handled and perhaps misstepped with regard to certain aspects of thinking through, not perhaps did misstep, with regard to certain provisions in understanding the Civil War amendments, applied to other types of constitutional transformation, and applied to dusting off or looking at measures that are underexplored. With regard to state constitution, the two core ones with regard to the argumentation and analysis, avoiding the strangulation problem. And it's there, it's a constitutional measure. What's the effect supposed to be? Court shouldn't strangle it. They shouldn't not give it effect. And the overreaching, the sort of the Icarus problem, they flying too close to the sun. Somewhere in there, there's a balance, a healthy balance of constitutional development. And I think those lessons that we see with regard to constitutional change and transformation, with regard to the Civil War amendments, I think they have application when we think about constitutional transformation with regard to state constitutions. And with that, I think we've hit 1 o'clock. So I will go ahead and turn off the screen share and turn things back over to Mr. Cole. Thank you all for the opportunity to speak with you today.
Great, thank you so much. Everybody should have received an email today with the information to request your CLE credit. If you did not, please let me know and I will get that to you. But you all have a great rest of your day.
Thank you all.